The first court appearance is called the arraignment. This is a simple appearance where the judge asks you, how would you like to plead guilty or not guilty? Oftentimes people who are not represented by an attorney will plead guilty and the judge will sentence them right there. At that point, they have not reviewed a police report, they don't know the evidence against them, and they don't know what defenses they could have mounted. When you are represented by an attorney, the arraignment is a very simple one where you enter pleas of not guilty and ask the DA to give all evidence and give you time to review that evidence so that you can work out defenses and strategies to either get the case fully dismissed or reduced in a way that is favorable to the client. Generally, before you have a trial, you will have several court appearances where your attorney will go and meet with the district attorney, go over evidence, and try and negotiate some sort of resolution that is favorable to you. Obviously, your attorney is going to try and find facts in the case and different factors by which the case can be fully dismissed. If the facts of the case don't warrant a dismissal, then your attorney is going to go in and try and negotiate the charges down to a lesser charge. Or if you're being charged with a felony, try and get a misdemeanor charge for that. Sometimes the facts aren't going your way and are really strong against you, so it's a matter of damage control. Having a good attorney who knows the DA and knows the court system where you're having your case can really help you to minimize the jail time and to find alternative programs to jail, alternative programs to the punishment that they initially want for you. In order to be convicted of a crime, the district attorney needs to have evidence that proves beyond a reasonable doubt that you are guilty of the crime for which you're charged. So it's very important to have your attorney look at the evidence, to look for issues like an illegal search or seizure, to look at whether or not testimony is reliable, to look at different issues with evidence that can either have that evidence thrown out so that it can't be presented at trial, or offers an explanation to that evidence that puts doubt as to your guilt. Evidence is very key, and having an attorney who understands the rules of evidence, how to look at evidence, and how to break down that evidence is very important in your defense. As far as trial, generally a trial is all or nothing. You're looking at getting your case dismissed or having it fully convicted. Rarely at trial do you have the charges reduced or have a lesser charge by which you're convicted for. Because of that, you really want to go in and spend as much time as you can trying to negotiate the case, trying to find options for resolving this case that are favorable to you and acceptable to you. Once it's resolved that negotiations aren't going to happen that are favorable to you, you can set the case for trial. Sometimes setting a case for trial is just what you need because the DA will then give you the offer that you want because he doesn't want to try the case or maybe is having a hard time getting witnesses to appear. Other times it can blow up because the DA will tell you all offers are off the table and your life is in the hands of a jury and a judge. If you found this video helpful or have any questions, call Earl Carter and Associates and we can help you with whatever you need.